George, you got me?
He said, I got you.
Ready? Let's get going. I'd like to welcome everyone to the October ZBA meeting. Noreen, you like to do roll call? Okay.
Evan Scully,
Present.
Marcy Daniel. Chip Postiglione.
Here.
Steve Thaw.
Here.
John Seeley.
Yeah.
Thank you.
No, thank you. Please stand for the pledge. Please make a note of the fire exits, two behind you, and then behind the dais here. Thank you. Okay, first up, we have a continued public hearing for Leibowitz, which we were just discussing, has withdrawn their application, correct? So at this time, I guess Dave was just saying that we'll just mark it down withdrawal. Do we have to close? Do we have to make a motion to close?
There's no longer an application. I mean,
Okay.
technically, if you'd like, if there's some reason that you. Head on now, George? I mean, again, I've seen it done both ways. You could simply mark it as withdrawn because the applicant has withdrawn it. If you want, you can entertain a motion to accept the withdrawal. I don't think that's procedurally necessary. But
Sounds good. We'll just go with, we'll mark it as withdrawn and we'll be done with it.
Yep.
He's been stringing us along a long time now.
Couple months.
All right. Next up, we'll do a new public hearing for the Town of Monroe Planning Board. I'd like to make a motion to open up the public hearing.
Second.
All those in favor?
Aye.
Aye. Please step forward. How you doing, Bonnie? Doing well.
George, did you say? Is this on? Okay. I did. I wasn't sure if you wanted me here or up there, or if this is okay. If public comment? Okay, thank you. So this was discussed prior to opening this public hearing at the prior, I think,
September, yes.
right, September Zoning Board of Appeals meeting. Again, I'm Bonnie Franson. I'm the Planning Board Chairwoman, and I'm representing the Town of Monroe Planning Board in regard to this matter. And our notice of appeal has to deal with the Summercrest LLC community, which was before our board because it had been determined and designated historic property, which required that then they come before us for exterior improvements. And during that process, as part of our application, we asked the building inspector, well, what are the uses of the various buildings that are especially subject to these improvements, so we would understand, in part, how they should be improved. And the building inspector came back and designated them, I believe, some of them as single-family dwellings. And our primary issue is, frankly, the planning board sees this as something and a property that was a summer bungalow community. It stopped to operate, for the most part, as a summer bungalow community. There are a couple of houses that continued to exist and continue to be occupied, but you can see from the various pieces of information that you have that many of them are, in a range of dilapidation and state of repair. Some of them don't even look usable. And I was thinking about what is a kind of an analogous situation to compare this to. And I don't know why I didn't think about this, and the board didn't talk about this previously, but it's like Rosmarin's, right? They have their seasonal bungalows that are part of the operation, that people, when they stay up there, they stay in those bungalows, but at such time that it stops operation, it ends, it ceases. That's what a seasonal bungalow community is. That stopped operating, essentially, at this Summercrest colony. And what's happening now is those buildings are being renovated for single-family, year-round purposes, and or there's a proposal to renovate them for that. And from our perspective, calling them single-family dwellings, first of all, that's not what they are at this point in time, because they were summer bungalows a la Rosmarin's. And to be able to use it for those purposes, we believe it may require variances or some review of the code to determine whether they can be used legally for that purpose, because we find that they really fall under the non-conforming use provisions of the code. So whereas summer bungalow communities that are bona fide and continued in existence, like a Rosmarin's, is something, from our perspective, that would be a continuing situation. This is not that. And so we're in front of you to appeal that decision of the building inspector. And I think it's important to make that determination so that then the applicant has the appropriate route to pursue whatever it is that that individual wants to pursue going forward. Planning board does not have an opinion, nor did it express any opinion of whether what is happening there is good, bad, or indifferent. We simply do not believe that it's a conforming use, that these can be converted without some oversight in some way, because of the fact that it's a discontinued non-conforming use. That's our perspective. And so our planning board attorney, Ashley Torrey, had put together our notice of appeal. The information's in there, and we've submitted this for for the appeal of that determination and your consideration and decision.
So, thank you.
You're welcome.
So after last month's meeting, went through all of this a few times. Pretty proud of myself for that one. It's, after speaking with some of the members of the board, it's a layered, what's in front of us is a layered process, I believe. And after speaking with Dave, I see why it's here. I see why you're asking for this. I also see, as we were going through this, now that it's been designated an historic site, brings in the question of use.
Correct.
Right, that needs to be answered.
Right.
Also, and Dave, jump in whenever I get off the rails here. Also, I think we would also like to hear from the planning board attorney.
Okay.
Because I think that there's going to have to be some splaining to do. And unless I'm overthinking what I read, Dave, or not knowing, not being a lawyer, to get more clarity, does that make sense?
Yeah, I think everybody here has read through it, including me, the application, And when we were here last, before the hearing started, obviously it's starting today, but there was a letter that had just come in, I think that same day or thereabouts from the,
Got it that night?
the representatives from Summercrest, the law firm.
Actually in the packet.
Yeah,
given
we
to us
have
by the
it.
planning board.
Yeah.
It was I think they may have submitted it that evening or shortly before that, but yes.
When I was going
Yeah.
through the packet, I found that
Right.
again.
Okay,
I just know that there was that letter September 26th that came in, and, I saw it just before I came up here for the meeting last month and didn't have a chance to, really comprehend it or, read through it. But obviously for preparation for the hearing, I think we've all taken a look at it. So I think they raise a lot of legal points, and I think there's some, I think the board would benefit from hearing a response to the legal points raised, and so they can see it in context with what the applicant is saying, and, the applicant being the planning board, what the planning board is the applicant here, squaring up the arguments to
Okay.
help the board understand what are the arguments before it, and what do you have to say about their points in regard to advisory opinions and, all the different, myriad things that they have in opposition.
Are you contemplating almost like a memorandum of law, or you just want to have the individual or attorney appear before the board, or what
Well-
are your thoughts, or I guess, what can be communicated to her in terms of what are the ZBA's questions, or
Yeah,
what's
well,
perhaps
I think
confusing?
I think the application is, I think, as Chip said, it's got, some layers to it. There's some legal issues, but there's some factual issues. But it seems to me that, the issue that, and there's several issues that the planning board has brought to this board. It looks to me like the primary one is that, it requested this determination of use in connection with its review pursuant to, Chapter 57-32. And, as the planning board was required to do, it inquired, among other things, in applying its criteria, what the use was and what the legal uses were, and requested that determination from the building inspector. The building inspector then made a determination, and then you brought that appeal. And I think I think that's how you've gotten here. But I think what the primary basis of the appeal is that, if I'm reading it right, is that there was an abandonment, that there may have been a pre-existing nonconformity that was specifically allowed by code if it was in use as of a particular date in 1954.
Yes.
And then there's a second code, I forget the numbers, but
Provision.
Provision that said, yes, you can have nonconforming uses, but there can be an abandonment of nonconforming uses.
Correct.
And you're advocating that they've abandoned, in whole or in part, some of the various uses. I mean, there's so many buildings on there.
Correct.
And the property owner, among other things, is saying that maybe there wasn't an abandonment, or there was only a partial abandonment, and they're taking issue with some of the facts, but they're also taking issue with some of the law on that, in terms of which code applies. How do you interpret the code?
I
So
recall seeing that, because I think that there was some argument from Summercrest that one of the sections superseded another, and I don't believe that's the case. So I'm familiar with the points that you're raising.
Yeah, so I think, to answer your question directly, and I think, it being a public hearing, I don't know I think the property owners may have representation
Representatives,
here.
you're correct.
They can, I'm sure they'll be asking to speak, I would imagine.
Okay.
But I think that there's fact issues as to what was abandoned and where and how and whether it was abandoned, and what the import of that was. And then there's a separate layer of legal issues on code interpretation. So I think the hearing is probably going to have to address both those things.
So there are some buildings that you can see are in an incredible state of disrepair, and that there is no way they've been occupied and meet the standard for continuance of a nonconforming use. But are you asking then for additional information to try and date that? Or,
I don't think so. I think what you just explained is like the the low-hanging fruit, right?
Okay.
We can see that, right?
Okay.
So we could see the state, in your package here, we can see all that. It's the more where the legal use or the legal interpretation is going to be really key on how we hear that kind of information that the board might not understand, and then we'll have to lean on the legal counsel here.
Now, can our counsel speak to your attorney, just so that there's a, kind of a common language in terms of what she should then be presenting? And is it something that you want her to be present here at a hearing, or is this something that you want a response to in a formal letter?
Well, it's really up to you guys, right?
Okay.
I mean, it's, even though you're a town board, a town, related entity, you're an applicant, so we can't necessarily tell you exactly what to do,
Oh, okay.
right? So
Yes.
I think the chairman and I think with my assistant, we're issue spotting in terms of if we're going to have a hearing. There's some fact issues that I think are going to come up, and there's some legal issues, and I think the board would benefit from, hearing both.
Okay.
In some format.
Now, are we going to get some kind of list of those in advance? Or, again, this is something that you just want to go through with our attorney present? How are we going to receive that information with regard to those issues?
I mean, it
Or
could
we're
be
gonna
in
hear it this
writing.
evening.
It can be, any hearing is a combination of sworn testimony. If you have people that, that want to, testify about what uses are there, or what uses aren't there. You want to make legal presentations. It can be in person. It can be in writing. It's all comes into the record. So long as it's in the record, and there's an opportunity for the public to speak and to be heard, so the board can be fully informed and understand, have a real, a depth of understanding
Okay.
of both the legal and factual issues. And then they can, figure out exactly what they want to do here.
Okay. And again, it's just, I'm hearing that there's some questions you have, so I don't know if that's going to play out in this public hearing, or if we'll get something, or I guess we'll see
think-
how the public hearing proceeds, and then
I
go
think
from
it'll
there.
probably end up being played out in a public hearing. Like counsel was saying, we can't tell you how you want to do that, if you want to bring your lawyer here. But if they were to come here, and there would be an open discussion, and then this is where all the layers come into play, then after that, there might be some pointed questions
Yeah, I mean,
derived from
yeah, and
that.
And if
Yeah.
I might interrupt for a second, I think I don't want it to get, too complex or
Right.
obtuse, right? I think at the bottom line is that, the application is pretty clear. The property owner has submitted a 3 or 4 page opposition that raises questions. And I think what the board wants is, you've got an opportunity to respond and talk about what do you have to say about what they have to say. And I'm sure they're going to
Okay.
be here, and you'll hear what they have to say. I'm sure that they're going to expound upon what's in their letter, and maybe there's other points that they're going to come forward with.
Okay.
And, the board's going to want to hear both sides on all issues.
Okay.
That's all.
Yeah, it's well said, Dave. Does the board think that we want to hear from the building inspector? Does anyone see a value in that?
Point he's already made. Yeah, I don't,
I mean,
unless there's something I'm not seeing, there could be a value in it.
There might or may not be. I mean, we've barely started the public hearing, so I think that would be, that's an open issue.
I do want to just mention for the record that we had our public hearing on the exterior improvements, and we did render a decision to approve it, because that's something separate and apart from this interpretation that we're requesting. And it was based on our advice of counsel that, there's not quite that, there's not linkage when it comes to the exterior shell of the building, which was being approved. And so
It's hard to say.
know, it's hard. Some
How
of this
can it
stuff
be
is
exterior
high-
when there's no roof?
Well, I know, and so I don't disagree with you, but we could only act on the application that was in front of us, because the building inspector had forwarded that part of it to us. And we can certainly send you a copy of the decision, because I think it was written in a manner that was very clearly limiting in terms of what we were approving. I hear what you're saying, and it's something that we considered or discussed. And again, we went on advice of counsel that it was specifically the roofing and the siding. Part of me feels that, well, to have a siding, it has to hang on something, and to put roofing, there has to be a roof. But we limited ourselves to what we were approving, for what it's worth.
When was that? The approval?
When was our meeting, Noreen?
That was
17th.
just your
Good night,
last,
17.
your
Yes.
last meeting, right?
Yes.
Yes. So during your meetings, during the planning board meetings, is there a clear use of what they want to do? Right? And to me, that's like the low-hanging fruit, which I was alluding to before. You know, when you read the package and knowing that it is historic, designated historic, it clearly states that, you know, what is the use? So I see where
That's where
you're
we are.
coming. I see where
Exactly.
you're coming from. I do. I understand the value of wanting to know that.
We specifically asked that. Applicant specifically was indicating he was not going to answer that question. And that he talked a little about some of the adaptive reuse provisions that's in that historic preservation section of the code that talks about you're able to use buildings for certain purposes if you adaptively reuse a historic building. He talked about maybe having some kind of seasonal bungalow community again, you know, as a little destination. I'll tell you that there's public information out there that suggests other uses, but when it comes to actually nailing down what the applicant wanted to do, he said, I'm going to figure that out at another time. And all I want to do is put a roof on, put siding on to protect these structures from the elements. Yet, from our perspective, when video was submitted, it shows that there's a lot more going on with regard to reuse of the property. And then in receiving Ben's determination and referring to these buildings as single-family dwellings when they were used as seasonal bungalows was very troubling to us. And so that's why we're here. Because ultimately, we wanted a determination from this board, because then that plays into should there be any further review or approvals of the reuse of something that we opine has been abandoned. That it was a kind of legal, non-conforming use as a summer bungalow colony, but it was abandoned, with the exception of a few of those buildings that appear to have been used. We don't know when, we don't know how long, but you could see from their state of existence that they've been around longer, you know, and have been in use and certainly in use at the time that it came before us. While it's obvious that there are other buildings that simply are not used, haven't been used. So, you know,
There
again,
are some inconsistencies, because you just brought it up, you said single-family dwellings, which says it in the packet even here, but in the letter, it states that there's multifamily.
I think there might be a two-family in there, yeah. And that's a Ben determination. You know, that wasn't our determination necessarily. I believe there might be a unit there that may have been, based on public information that's available, that there may be a unit that was actually restored to single-family use after the the applicant purchased the property. So we have not gotten any clear determination from the applicant as to what he wants to use it for. And we initially were not getting a clear determination from the building inspector what these uses are what's all this work being done at this property, for what use, what is happening there. And finally, our engineer reached out and said, we need this information. It's part of our application process. And that's when we got the list. And when we saw it, we're like, I think we need to question this determination. So again, why we're here. And I want to impress upon everybody what the applicant wants to use it for. He has a right to apply for things, to try and use the property in whatever manner, he would like to see. But there are regulations, zoning, otherwise, in this town. And does he fit within that zoning and within those regulations? As has been interpreted by the building inspector as well. And if not, then there's a process. If it is, then he'll continue on.
Any comments from the board members up here?
Planning board.
Ceilings or roof?
It was
Sealing the exterior.
Sealing the exterior.
So
We-
roof, siding.
It was siding and the roof.
So, because it's clear some of them are total reconstruction.
There's no wall to put a siding on,
So
or no roof.
couldn't
to
approve
put a roof
individually, it
cover
had to
on.
be all
Siding
19?
is just the style of the siding or
It was the type of siding.
type of siding?
It was the type of siding, and we specifically identified the buildings that had been requested, which ones they could put that siding on. But we acknowledge that if he needs building permits to be able to do additional work, there's a process that he has to go through, either through the building department or whatever the process will be that plays out. But we were just limiting our historic preservation role to the type of roofing and the type of siding. In fact, I think we said things like, this does not include new windows, this does not include, there were various elements that we said that this does not include. And we will get you that approval decision.
And that was what, a certificate of appropriateness?
Correct.
Okay.
Correct. I think that's what we issue as the Historic Preservation Commission. So as I said, it was very limiting. Noreen, you don't have a copy here, do you? Oh. Let me grab it. So Ashley had to send me the revised version based on what we discussed that evening and making revisions and discussing it. So, to allow alterations to the roof, siding, and other exterior elements of 13 structures. 23 Pinecrest, 27, 33, 35, 37, 39, 43, 47, 49, 51, 53, 55, and 57. So that's 13 structures. We lay out all the materials that have been submitted. The application was before us on May 31st, 2023. We held our public hearing. For our approval, it's considered a type 2 action. It is a certificate of appropriateness that was granted. And I'm just trying to get through something. So one of the findings, the history, use, occupancy, and ownership of the property. In considering the use of the property, Planning Board notes that the applicant has not identified a proposed use of the regulated structures and requested to obtain approval for the proposed alterations separate and apart from any approval of the use of the structures. Throughout the Planning Board's review process, applicant has acknowledged that it is proceeding at its own risk in this regard. Implying the principle of compatibility, the board has considered the prior use of the structures as a summer bungalow community, finds that the proposed alteration is compatible in this context. However, the planning board notes that such use is non-conforming and may no longer be permitted due to abandonment. Planning board thus determines to condition this approval on the applicant obtaining all necessary approvals for the reuse of any abandoned structures prior to any further issuance of building permits, i.e. permits for work other than that which is the subject of this approved certificate of appropriateness or certificate of occupancy for the same, unless the ZBA opines that such approvals are not otherwise required. So our approval appears to be conditioned on your determinations.
Can I ask, I think what might be either a very pointed question or a very dumb question, or one that maybe we just don't know. Did Ben Maldonado determine what the last legal use was at some point in time? Or is he making a determination that these uses on this spreadsheet are in fact legal now without requiring any further applications? I'll be honest with you, I can't tell from reading the request for the review, his response, or the spreadsheet what his determination actually is. And it seems to me that what your application is a precautionary measure in case it be interpreted that it's legal right now no matter whether it was abandoned or not. Yeah. And it might be that that's not a determination that he even made. I can't tell. Can anybody tell me that? Do you have anything to say about that, Bonnie?
No. Again, that's why we're here. We don't understand how that could be a determination, especially for buildings that are practically non-existent and falling down.
Getting back
As
to our
I
earlier
look
question,
through it, that's why I thought that it would make sense to have the building inspector here. I know he gave his thoughts in a letter here, but it's not crystal clear to me,
Now-
so he could send them all.
Now I feel that, yeah.
Yeah, all you have to do is read this.
Yeah. No,
It's here.
To your point, Mr. Seeley, we said this is limited to installation of the new roof shingles and siding and does not include any structural or other approvals required to install said roofing and siding. Or whomever brought that up, that you have to put it on something.
Yeah, there's no walls, there is no roof structure on some of them.
And I didn't hear the answer to John's question on all night, when you gave approval earlier this month, it was for all structures?
It was for 13.
13? Okay.
Correct. And we indicated that any additional work that requires historical review by the planning board, including but not limited to replacement of windows and or foundations, to the extent the building inspector determines such work requires historical review by the planning board, should not be commenced unless and until a new application for a certificate of appropriate is submitted. So we get into the colors, we talk about the materials.
Their designation as historic, that was brought upon by themselves?
Correct. So it was not on the National Register. It was not National Register eligible. The applicant represented that the town historian came to the property and made the designation.
So where I'm having a difficult time grasping this with, if he brought in the designation on himself and he's reluctant to say what the use is, he brought that upon himself. So that's, you know, it's just an onion now, right? This is what it's starting to get really peeling of why,
Letter from Summercrest LLC, it states that there's multifamily homes in there. And this, it's all single-family homes.
So we understand where you are because this is where we were in our review, and hence why it's very limited in scope. Why we asked for the building inspector to make some kind of determination, and so that once it came, we appeared before you to get some.
How
hopefully
does
clarity.
the recreational hall and barn fall into this?
I believe we included that in our determination, although I know that the applicant has already done repairs to the
Yeah.
casino. You know, whether there are any additional, you know, that, I guess that would be down the road. And use, have no idea.
If
Well, not necessarily, but, well, I'm thinking about this adaptive reuse section. So for example, you may have a historic home, let's say, you know, if you're in the Village of Monroe, right, and you're on stage, you have those historic buildings over there. So they may have been used historically for residential use, but they could be repurposed for an office, but still keep their character from a historic perspective. You know, whatever it was that,
appearance,
Yeah, the
so
appearance.
especially the appearance, but the use itself, it comes down to what the zoning would allow there. So unless they've been used continuously, let's say it's a home, and let's say that zone went to an office zone. If they continued to use it for residential purposes, it could continue. But at some point, to convert it to some alternative use, I think the zoning would kick in, separate and apart from, you know, ensuring
HIPPO.
that, you know, if you have a historic preservation section of the zoning, that you are still complying with that, plus still complying with the zoning for whatever use is allowed within that zoning district. Our town code has some sections that talk about, as an incentive to reuse property, that you could put it to other use. So for example, maybe you could use it as a restaurant. You know, maybe you could use it, I'm just throwing out examples.
but you would still have to keep it
You have to
historically
keep it
correct.
historically correct.
With the colors, the sconce, whatever,
because-
whatever would be done, and I think that was your
Yes.
point there, right?
Yes, because that's the reward. We're not going to give you a use simply for you to tear it down or to
Right.
alter it to a point where it no longer has historic character. It's a reward for, and we say that you have to keep it, you know, the exterior or whatever it is that made it historic, you have to maintain that.
Bonnie, just circling back to, you said there were renovations made on the casino and the barn. Do you know if those renovations were made prior to the request of the historic designation or thereafter?
They may have been done prior. I think you would have to look into Ben's records, see if anything, you know, was issued for building permits or whether building permits were necessary. That really hasn't been necessarily the focus of our review. Again, I think there's public information out there where the applicant had hosted an event there, I think at Easter time. So I believe that was before they came before us, which was in May. And, you know, I'd have to look back to when the historian did the designation. But I think some of the work may have preceded that.
Know if anything's been done to the barn?
I am not sure. I am not sure. We were allowed to go out there, but then frankly, at one of the meetings, it ended up very testy and felt a little threatening by the applicant. So I don't think anyone's felt comfortable going out there. The applicant did provide a video, which I think I mentioned at the previous one. I know that it's on, they have a website, or a Facebook page, and I thought Noreen said you got a copy of it?
Sent to
Right.
us.
So
On
you
our
have that?
website.
Okay, so
Sent to us.
that's essentially, what we've seen as well as the photographs. And I don't know if you've had a opportunity or if you're thinking of going out there.
We would need permission. You're the applicant. You're not the landowner. Wouldn't we need permission, separate permission from what your permission was?
The planning board has written approval
Oh,
for
okay.
you to do site visit.
We have on our application forms for
Yeah,
site
they
plan,
have the
Yeah.
same
a
thing.
checkbox to visit the site, but
But
it's not
you-
our site.
It's not your site, yeah.
So you would have to get that, I guess,
separate
from,
permission.
I have to either get it from Mr.
yeah, and the attorney's here, so,
When Mr. Mitz was at the meeting the other night, I told him Zach had asked. And I
oh, that's
told him-
okay. They're separate issues, so, you can understand why you don't think about it. These are two different matters here.
Any questions?
No, but I think it's our question, your question was answered about having contact with the building inspector.
Yeah, just for clarification, because
Yeah.
it's very cloudy, very cloudy.
Mentioned earlier, I think we're going to need to, at some point in time, hearing.
Yeah.
Like there's a question in my mind, like right now, and again, maybe it's putting my finger too directly on, the issue, but you take any one of these spots that in the spreadsheet, I'm just going to pick one out. I don't know if it's one of the address number 51. It's listed in the use column as seasonal summer dwelling. Let's say it's one of those dilapidated old buildings that we've seen a picture of. What would be the process to put that building into use and occupiable and usable as a seasonal summer dwelling? Has the person been given carte blanche to do that by reason of this spreadsheet? Or is there still a process by which he's going to have to make an application for a building permit and so on, with this spreadsheet of Ben's having nothing to do with it? Or is this the determination that it can be, and he's just got to, satisfy building code, and then he can put it to use? I think that's what's unclear to me right now.
Yeah, or like whatever's needed, is it per building? Or is it compliant, is it an umbrella over it
Yeah.
all? And,
Yeah, maybe I'd like to hear, maybe we can hear from, the property owner.
Yeah.
I'd like to hear that view as well. And
Definitely.
from Ben and others. I mean, the board, at the end of the day, the board has to understand what it's deciding, and what can it decide and what the implications of a decision are. So,
Dave, if I were you, I wouldn't worry about asking pointed or stupid questions. Everyone knows that stupid questions is my job.
There's only one stupid question, it's the one not asked. We all learn that.
Thank you, Bonnie.
You're welcome.
Thank you.
Do I sit over here?
Yeah,
And then
please.
Okay, thank you.
Thank you.
I'd like to see if there's anyone in the public here that would like to make any comments. If you do, please just come up and state your name.
And talking to the mic.
Yeah, please.
Good evening, everyone. My name is Jonathan DeJoy. I'm the attorney for the Summercrest.
Little closer
Oh,
to
you
the
turn
mic.
that microphone on. Sorry.
There we go. My name is Jonathan DeJoy. I'm an attorney for the property owner, Summercrest LLC. Sounds like everyone has got a chance to read my letter from last month so far. I have another one that follows up on that. I'm going to give that to Noreen. I don't expect anyone to read it right now, but it sounds like the public hearing is going to be continued anyway.
Yes.
So really, there's two main things at play here. One is that the law is very clear that a use, if it's abandoned, has to be completely abandoned. And that's because buildings and structures don't have uses, parcels do. That's why on a zoning map, It shows each parcel, not buildings or structures. And so here, the use, well, as a bungalow colony, has never been abandoned completely. You could tell from looking at the pictures, some of the buildings are not occupied, but others have been continuously occupied since the 1930s when this property was developed. Now, as far as the buildings that the building inspector determined were single-family uses, that's a permitted use in the district, so that's really a non-issue. I mean, there's no way that the town or anyone could find that these buildings couldn't be used for single-family because it's a permitted use in the district. Now, the other thing at play here is Section 5762 of the code, which specifically makes an exception for bungalow colonies that existed prior to 1954, which this did, and it exempts it from the other provisions concerning abandonment. It specifically carves out bungalow colonies. If the bungalow colony existed prior to September 1954, the third day of September 1954, it may continue in perpetuity. And that's, clearly what we have here. Nobody's disputing that this property has been a bungalow colony since the 1930s. And there's been some talk of summer bungalow colonies, but when you read the code, it's not a summer bungalow colony. There's no definition of summer bungalow colony, and that term's not even used. It's just bungalow colony. Now, it's not defined, but it describes the property here.
You're saying a bungalow colony is not defined?
That's correct.
Okay.
And it's not referred to anywhere as a summer bungalow colony, just bungalow colony. So, and just to be clear, we did receive the certificates of appropriateness from the planning board last week, and all of the buildings subject to those certificates will be restored to look as they have always looked. So the visual outside appearance is not changing at all. Whatever they are used for now or in the future, they're going to look the way they did in the 1940s.
Can I ask you a legal question? You mentioned before, you said that the section 57-52 exempts bungalow colonies from the exemption, from the abandonment provisions of the code. On what basis do you say that?
Well, because if it didn't, then this provision would have no meaning. I mean, it really just describes in general pre-existing non-conforming uses, but by specifically carving out and enumerating bungalow colonies, you have to read it as an exemption to those abandonment rules.
So you're saying only because it says in the code that a bungalow colony that existed as of September 3, 1954 is essentially a non-conforming use, that the next section after that talks about non-conforming uses being abandoned, that it does not apply just because it was specifically called out?
Yeah, and it's actually that the section on the bungalow colonies, the exception comes after, which might seem trivial, but I think it's important because whoever drafted the code specifically put that after abandonment. And like I say, if you were to read that as though it was subject to the same abandonment provisions, then that section would have no meaning because it would be just the same as any other use.
Is it different because that section simply identifies the date by which the bungalow colony must be in existence in order to get the benefit of that section of the code?
I don't read it that way, no. I mean, I think if it specifically said that the code was changed in such and such a year to prohibit bungalow colonies, then maybe, but I don't read it that way. And, zoning, to the extent there's any ambiguity in zoning codes, it has to be construed in favor of the property owner.
Do you know of the date, that date that's in that section of the code? I think it's September 3rd, 54. Was that the date of enactment of the code, or is that some other date? Is there a one-to-one, or you don't know?
I don't know.
Are you saying that it's been used as a bungalow colony or rental summer cottage?
Continuously.
Continuously.
At least some of the buildings have, yes.
So the question I asked the applicant before, I wonder if you could give me your view on it, and give the board your view on it. If there's, is it your understanding that the determination that is at issue here, that spreadsheet, is that determining what the current actual legal use is so that no further proceedings are required if you put it to that use? Or is that determining what the last legal use was that was on file at the town was?
It's a little unclear to me as well, but I think it's referring to the current legal use that may continue. But again, as I said, the law does not prescribe uses to structures, it prescribes uses to properties. So with all due respect to the building inspector, this spreadsheet doesn't, totally make sense to me.
Well, but it does, but the code does talk about different structures and allows the building inspector and it allows the town to regulate what uses can be put to which structures on which properties, right? Like, you can't have multiple, you can't have two dwellings on a property if that's what the code says, but you can, if one of them is an accessory garage, those regulations apply to the whole parcel, but the code is specifically regulating the use of each of the buildings. It doesn't just cast a blanket over it and say you could use it, use it for one, use it for all, right?
No, I don't know that I would totally agree with that because, the use is defined in the use table and in the zoning map. So to me, the building inspector could maybe find that the property has two uses, but I just don't know how you can assign a particular use to a structure. I mean, you could use structures for a variety of different uses. Now, maybe if it's like a gas station or something, you can't use a gas station as a single-family home. But here, these are pretty, they're just small buildings that could be used for a dwelling. They could be used for an office. They could be used for a lot of the different permitted uses under the code.
What would be the process, like the question I asked the applicant before? If you take, I'm going to make it up, building number 51 on Ben Maldonado's spreadsheet, it says seasonal/summer dwelling. I don't know which one's 51, but let's assume that that's one of the ones that we've seen pictures of and it's just wiped out, right? What's the process that you see on behalf of the property owner to put that building, that particular building, to use as, a bungalow or a seasonal summer dwelling or even a single-family dwelling?
Well, I would say for a bungalow colony, if we're to treat it as a pre-existing non-conforming use, then the building inspector would, that's his call, but he would just have to issue a building permit. And for single-family, same thing, just a building permit, because single-family is a permitted use, so there's really no question there.
It's just a matter of, you'd have to put in a building permit to do that.
I believe so. I mean, it would be up to the building inspector. He could always deny that permit application.
And would you intend to take the position that Ben Maldonado's determination here is controlling? Or are you taking the position that that's not controlling?
Well, I mean, yeah, I would say it is controlling. He's the building inspector. It's his call to make.
So then, in your letter, you're saying that this is just an advisory opinion, but yet here you're saying it's not. You're saying it's controlling, so it's not advisory.
So the advisory opinion, the planning board is also asking the ZBA to determine what the buildings could be used for and whether variances are needed. The building inspector never opined on what they could be used for or whether variances would be needed. So that's really beyond the scope of his determination. The only question is whether they can be used as single-family or bungalow colony.
Being asked that? No. We're not being asked that.
That's how I read the planning board's appeal. I mean, that's, they've made, argued at length about abandonment. That would certainly go to whether we can use those structures for what they've been used for.
Oh, okay.
Okay. Do you have any historical information that would assist the board in determining what, and I understand that your position, you've stated it clearly that the board shouldn't be unit by unit and determining which was abandoned. I get that.
Right.
Do you have any historical information to assist the board in determining which buildings have been used and during which time periods?
My client may have some information. We submitted a FOIL request to the town for the records for the property. That was denied, so we're a little bit limited there. I would be happy to try to answer any specific questions, but, beyond that, as you said, our position is that because some of the buildings have always been used, that, the rest is really irrelevant.
Is there proof that you can give the board that some of the buildings were continuously used and there was never a point in time that they were abandoned for more than a year?
I can get an affidavit or have my client come to the hearing and
Yeah,
testify.
I think the board would, again, understanding you've made a legal argument. I don't mean to say it's valid or not valid. I understand it, but in the event, obviously the applicant is taking a different position, so I think the board would benefit from whatever the applicant can provide and whatever you can provide
Definitely.
in terms of what buildings were used during what time period and what, when they were out of use, proving that they were in use, whichever ones were in use, whatever you can get to, so we can eliminate fact issues.
Sure.
If we're all operating under the same set of facts, then it's just a matter of, what the legal interpretation is.
Right. And of course, we do want to eliminate those fact issues, but I would also respectfully remind the board that this is the planning board's appeal, and it's their burden to show that the building inspector is wrong.
What's confusing me is, even as you speak here tonight about single-family bungalow, as we read the packet here, they refer to multifamily dwellings.
So I believe one building has been used as a multifamily dwelling. Obviously, that's not in the building inspector's determination, so if the property owner wanted to preserve that use, that would be up to him.
Say that again?
If the property owner wanted to try to preserve that building's use as a multifamily dwelling, that would be up to him.
So you're saying that building was always a multifamily building?
That's my understanding.
We know, just to try to get to some of the fact issues here, I'm looking at the spreadsheet. Do we know which of those addresses are the ones that we're talking about that might be two-family presently?
I don't know off the top of my head, unfortunately.
41, is 41
It could be 41. But don't quote me on that because, like I said, I'm not sure off the top of my head.
That's something that you can get for the board?
Yeah, like council said, any information that you could share with the board to help understand this complicated issue would be much appreciated.
Sure.
I'm reading a letter from the engineer that says that the applicant to the planning board identified Unit 41A and B as only one two-family house.
So is there a way to prove that 41 was always a multi-family dwelling?
I believe we do actually. My client has been in contact with someone that lived there back in the 70s who was willing to submit a letter and an affidavit confirming that.
So do I understand it wrong? Now, here's a stupid question. You knew it was coming. You started out by saying that the parcel, it's not the buildings, it's the parcel,
Right.
right? But now, as we're talking further, we're breaking it down to buildings.
Right. Well, that's because the uses manifest themselves in buildings. I mean, you can go to the property and look at it and see that it's a bungalow colony just by looking at the buildings. That's where that comes from. Now, whether you can look at it and say that it's, year-round or seasonal, you can't do that just by looking.
Yeah, but to counter that point, you could look at that property and say, yeah, it's a bungalow colony, which I agree with. But then how do you look at a bungalow colony and say it's a multifamily dwelling when it's a bungalow?
We'd have to have some evidence. I mean, I think the building, I honestly don't know what it looks like inside at this point. But
Right.
the multifamily dwellings are not a permitted use, so we would have to establish that it's a pre-existing non-conforming use, and we would have to get some kind of historical information to establish that.
Any other questions from the board?
No.
No, you good? Go ahead, Zach, what do you got?
The ZBA wasn't possible to,
I will have to check with my client on that.
What was that, Zach? I didn't hear what you said.
Permission to go on property.
currently the ZBA can't tour the building because we don't have any sort of document saying we can. The planning board could. So I'm just wondering if it's possible that we could get the same sort of approval if he's willing to allow us, just because we're talking about 17 buildings we've never
Yeah.
seen before.
Well, hopefully, as this process goes on, as this hearing remains open, we will get that. I'm hoping. Thank you.
Thank you.
Appreciate it.
Thank you very much.
Anyone else from the public have any comment? All right, so this is going to remain open. Oh,
Oh.
come on, Bonnie. Sure.
Yeah.
So in listening to some of that discussion, I don't think there's any relationship between the order of a section within a zoning code. The non-conforming section could have been in existence a long time. One could have existed. They could have moved around, zoning changes. There's just no evidence to support that, somehow because of the order of those provisions regarding seasonal bungalows and non-conforming uses that are abandoned after 12 months is a reasonable argument. Number two, I would note that the applicant purchased this property December 1st, 2021. That's over 12 months ago. And we are looking at pictures that were taken recently. It's not as if in the last 2 years, while he owned it, they went into that kind of state of repair, and now suddenly, it's only, less than a year that they haven't been used. So from our perspective, they've been vacated for over a year, for certain. And the other thing I would say is buildings do have uses. You have new construction where you can have retail on the ground floor and you can have apartments above. You can have a planned unit type development that has a retail building and has a residential building, and it may all be on the same lot. So I think it does matter. And I don't think you apply one singular use to all of the entirety of that parcel. And then lastly, why it's important, what you call it, if Ben is referring to those as summer dwellings, the ones that haven't been repaired and they have been vacated, they're not allowed anymore. And while single family may be allowed, our zoning talks about single family on an individual lot. It does not talk about multiple single families on a lot. So having that number of single families on one lot would not be permitted by this zoning. Single family, yes. Single family on an individual lot, no. So that's, again, our perspective as to why. First, you'd have to consider whether the density meets the code, whether it meets the zoning, and whether they need to get potentially variances to be able to reuse those buildings if they become single family. because it wouldn't meet the code, and it wouldn't meet that use, that specific definition, that it be on an individual lot. I just wanted to add those. I'm looking through my notes. That's it for now. And then anything we'll follow up with. Thank you.
Do you know, just while you're here, real quick, do we know, out of all the addresses that we have on Ben's spreadsheet, which ones fall into that category that you mentioned first that are they've been abandoned? That there's no question that they were abandoned even over the last year, and which of the ones are there's at least some question in that regard?
I would say what's been
I forgot
abandoned,
there's a map. Yeah.
I will say 20, because they're in the pictures. I would say 23 has been abandoned.
I think that was the barn.
That's the barn, that
Yeah.
structure. This one, I believe 25. Is that listed as a single family?
Yes, it is.
So I think may have been in use, not sure. This one, 27, appears to have been abandoned. The foundation is crooked, the building is crooked, there's moss, significant moss on the top of the roof. The stairs the stairs and the railing going up to the building are in total state of disrepair. I would say that was abandoned. 29, this looks like it's occupiable and may be occupied, and I believe they indicate that it is. There's also narrative that was submitted as part of the entity disclosure that said that the prior owner's son may live here. So that I believe that's 29. 31 appears to have had very recent work done on it. It has a stone foundation. It has what appears to be, I don't know what kind of walkway that is to get up to the first level. That's newer construction. And you could see it's new cement work, a new abutment to get up there, a new deck. I'm uncertain on this one, and that's 31. 33, I believe, should be summer bungalow. It's the one that's been repainted. Is that showing up as seasonal? Yes?
33 seasonal.
35, I think that has been painted. It's being fixed up. There's a dumpster here. I don't know whether it's occupied. 35, if that's seasonal or not. Seasonal. This, I'm not sure that this was not recently. This appears to have been recently fixed up. 37, completely unoccupiable.
That's
It's an understatement.
I don't know what this is. It's not labeled. It may be a building for which he wasn't even applying before us for. There may have been one of those. 39, not occupiable. Vacated. 41A and B, I believe that's the one that you're referring to as having been like a two-family or a multifamily of some sort. That's this one. And I think that one may have been in use. Whether it was converted recently or not, whether it was single or not, I do not know. But at least from the pictures, it looks like it's in use. 43, not occupied, vacated for some time. The casino. You could see they're doing, obviously they're doing work on it. They have some kind of either roofing, siding material, I don't know what that is, painting it. That's more recent. 47, not occupiable, abandoned. Windows in disrepair, looks vacated. 49, not occupiable, significant severe state of disrepair. 51, not occupied, significant severe state of disrepair. 53, roof caving in, foundations are falling apart, not occupied, severe disrepair. 55, looks like it's been abandoned, for sure. 57, this appears to be abandoned as well. Do you have color, did you get color copies as part of your packet?
Yep.
Okay.
Packet
Yep.
you gave us,
Yes.
not the
Okay.
big ones, but
59 looks like it's been split in half. Definitely not occupied for a while. And then we have pictures of Pinecrest Lake and other documentation and other pictures.
So
And-
Bonnie, I thought I heard the question or the statement that there was repairs that was granted and approved to be which dwellings that was approved?
I think you'd have to check, so there was a narrative here that was part of our packet.
I think that's what we were trying to understand.
Oh,
That was
sorry.
done.
Did I go off on a tangent? So there's a narrative there that says date of purchase February 2021, although our deed was December 2021, December, I think, 1st, 2021. So they were seeking certificate of occupancy for 15 units. Entire property located at Pinecrest Bungalow was poorly maintained. Building department's own records represent there were violations as confirmed in our purchase, that we took the property subject to any and all violation notices. However, upon our ownership, 4 of the buildings were rehabbed prior to the designation on October 4th, 2022. They were all kept in their original exterior look. Number 25 received no exterior repairs. The building exterior is primarily stone with aluminum siding on the upper level. 29 received a new roof, but no siding repairs. A permit was issued for this roof. So and I don't know what the dates were, because I think what was happening was Ben was issuing permits for the work on the various buildings and the repairs. But then, once that historic designation kicked into place, that's when it came to us. So that's when, and there's still repairs and there's still work going on out there. I don't know what's happening on the interior of those buildings. I don't know if Ben has allowed for work to happen beyond our review of the roofing and the siding. Number 31 received no exterior repairs. We did add a deck from the building to the ground. That might have been the one that I showed you. Allowed for entry to the second floor, as eliminating the entry from the first floor to the second floor. Makes it more handicapped accessible. So that's newer construction. 33 and 35 exterior walls were painted with a white primer. There's some siding repair needed using an asbestos similar siding look. Roof permits were applied for and completed, and repair the plywood underneath. 45 had a building permit issued to replace the roof, but no other exterior changes to the building except a paint job to clean up the graffiti. According to records found, a survey indicates property as it stands today was in existence in 1969. County records confirm property was constructed in the 30s, and that's real property, I think, that he's referring to, if you look at real property. So that's in that. I just want to look at the deed here.
Can I ask you to clarify the issue that you were making that brought you back up to the table about single-family dwellings, multiple single-family dwellings on one lot?
Correct.
Did I understand that? So your issue was, can you go
Sure.
over that again, please?
So when the zoning was written, which I happened to write, the town board at that time wanted the language to reflect that there would be one single-family dwelling on an individual lot, one dwelling per lot. That was because there have been situations where, let's say an applicant or developer comes in and they want to put 4 homes on one lot. What happens is those single families, they're actually condoized because they're not on their own individual properties. And from a planning perspective and a fiscal perspective, there are studies that have been done that show that if you had 2 by 2, side-by-side houses, one on an individual lot and one not, one being condo, one being fee simple ownership, they have the same exact demands placed on community services, et cetera, and they may even sell for the same amount from a market value perspective. The one is taxed less because it's condoized. And so there's a desire not to do that, to be able to, ensure that that among other reasons, that's one of the reasons why you avoid having more than one single-family dwelling on an individual lot. And so if there are 20 on one lot, that doesn't meet the code's definition for that use. So if someone came in and wanted to put 2 houses on one lot, that would require variance. And it's in the definition, so I don't know if that would be a use variance or an area variance. I think that would be something the ZBA would determine. But again, by definition, all those single families are not allowed if they became single families on one lot. So the argument that they can be used for single family doesn't mean that it meets all the other requirements, and it doesn't meet the definition for that use in the code.
Thank you.
Sure. And I don't want to speak about the deed. I literally just saw it here. It was provided to us. I think it's in your packet as well.
It is.
Yes, it
Looking
is.
at it
Right
actually
now.
did not read the deed.
Yeah.
Okay. So I have Summercrest LLC deeds. Perhaps it says this indenture made the first day of December 2021 between 25 Pinecrest LLC, domestic limited liability company located at 156 Grandview Avenue, Nanuet, New York, party of the first part, and Summercrest LLC, domestic liability company at P.O. Box 405, Blooming Grove, New York. So I thought that was the deed we were referring to. Perhaps there's something I'm missing here. Then there's maybe I am. There's a second indenture, 16th day of February 2022, and this is between Claire Runco, Claire Diliberti, Netta Mager, and Summercrest LLC. It could be that because there's multiple properties, that they just gave us multiple deeds. Even so, the ownership is still over a year, even at February 2022. And those are the two that we have here. So thank you.
Thank you.
Thank you.
Thank you.
Thank you.
As stated earlier when we started this public hearing, this issue has a lot of layers, and it's going to come down to hearing from all parties.
Yeah.
But I go back to when the gentleman came up for his comments on what's going on, and we said that a bungalow colony has no definition, right? So if we're dealing with definitions of bungalow colonies, summer camp, summer bungalow colonies, single-family home versus bungalow colony. Like a single-family home can be year-round. Can a bungalow colony be year-round? So it's going to get, this sounds like a big problem for lawyers.
You guys are gonna have fun.
Any other public comment?
So if I could just make one quick point about the, so the structures would be,
Speaking to the mic.
sorry, so the chairwoman's point about the structures, if they were to be used as single-family homes not meeting the lot density requirements, so as pre-existing non-conforming structures, meaning non-conforming to the bulk requirements, they would be exempt from the current bulk requirements. So, obviously, again, it would be up to the building inspector to make that call, but as I read the code, my client would not need any variances, any area variances to use each of the buildings as a single-family home because those are permitted uses.
Thank you.
Thanks.
Bonnie?
Except that the building department determined that those structures were seasonal buildings, seasonal bungalows, not single families. So they would be reused for a different use. And so it's possible that there would be zoning and bulk requirements that kick in.
Got it.
And you'd have to look specifically at that section of the code.
Thank you.
I'll stay here for a second.
Everyone good?
Yes.
Thanks. So this will remain open? And if there's...
You have to make a motion for
Yeah,
that?
why don't we make a motion to continue the public hearing on November 28th?
I make a motion to continue the public comment until November 28th.
Second that.
All in favor?
Aye.
Aye. Thank you.
Thank you very much.
Okay, next, continue, new public hearing for Kolowski.
Good evening, Mr. Chairman and members of the board.
How you doing tonight?
Let me just jump in. I think we need to need a motion to open the public
Yes, we'll
hearing.
make a motion. Sure. Just bear with us a minute, please. It's Kolowski, right?
Kolowski? Yes. Okay, let me pull it up.
Yeah, you need it? Okay. Like I said, this is a new public hearing, so I would like to make a motion to open the public hearing.
Second that.
All those in favor?
Aye.
Aye.
Thank you. Go ahead.
My name is Richard Krogan. I'm here representing the applicant. This originates from the building department issuing a stop work order for a second-story addition that started without permits. She then applied for the permits, and it was denied because compliance with the bulk regulations and the rear yard setback. We submitted plans to the board so the board could review the work that was actually done so that they would have clarification on that. And what we were asking for is the variance on the rear yard and the variance on the lot coverage. And basically, it's all because it's pre-existing. The property is the way it is. She hasn't made any changes to it, so we're just asking for the variances to be approved.
Just to jog my memory, all the footprints are staying the same.
Yes, they are.
Okay. But the
Pre-existing conditions, correct?
Yes.
But the changes that are being made are to the foyer of the one building,
Yeah, raising the roof.
raising the roof, and you gave us those plans. It's a pretty substantial change on that one building, right? We thought it was a little minor.
I thought it was a porch cover
Yeah.
until I got this.
Yes. And so the use of this what I'm referring to, what you provided us here. So I think you stated that it had a low, the entrance had a low ceiling when you came in, and you just wanted to raise it, and there wasn't, unless I'm mixing it up with another project we were working with, is that you had no intentions of doing anything upstairs. Is that correct, or am I
It would
wrong?
be basically storage.
Excuse me?
Just for storage.
Just for storage.
That's what she had indicated
I
last time.
just wanted comfortable entrance to the storage area, not some ladder. I just want stairs. I'm 60.
Does the board all remember, right, this here?
Yes.
Yes.
You can see that. Any questions? Any questions from the board here on?
Questions? No.
No? At this time, is there, I don't have any further questions. I appreciate you giving us all this and make it a clearer picture. With that being said, at this time, I'd like to open it up to public comment. Is there anyone out there that has any comments they'd like to make on this project? I'm seeing that as a no. And, if there's no other public comments, is the board feel comfortable with going to the factors?
Yes.
I do. Yes.
Dave, could you help us out with that, sir?
Yeah, so I guess the question, we can either go through the factors while the hearing's open, or if there's not, and see if there's anything more that you want to hear from from the applicant. Would you like to do that while the hearing's open, or you want to close the hearing first? You can do it either way.
Leave it open.
Yeah, if it
So you
doesn't
can
make a difference, yeah.
Get some feedback.
Yeah,
if-
just,
yeah,
I like
okay.
to work with a net.
Yeah, understood. So as the board is aware. Yeah, so it's a balancing test, as the board knows. It's the benefit to the applicant compared to and weighed against any detriment to the health, safety, and welfare of the community. The first factor is whether there be an undesirable change produced in the character of the neighborhood or a detriment to nearby properties that would be created by the granting of the variance. Anybody have any
I would
feelings
say,
on that?
I would say, in my opinion, no to that.
No.
A second.
No.
And the second factor is whether the benefit sought can be achieved through some other feasible method.
And no.
No. That's
The third is whether the variance sought is substantial.
In the grand scheme of it, of what they're looking for, no.
yeah. No. It's not.
Right.
The fourth is whether there be an adverse impact on the physical or environmental conditions in the neighborhood or district.
I don't believe
No.
so.
No.
And then the last is whether it was self-created.
Yeah.
No.
I would say yes.
It was, but what they're here is it was preconditioned?
Well, it's pre-existing non-conforming, so
Pre-existing, yeah,
therefore not self-created.
Right. Right?
Right, it's got elements of both, right?
Right.
You can't,
Yeah,
you know,
they're
it's
doing work
pre-existing
to it. I'm not
non-conforming.
Yeah.
saying that
No, that's true,
disqualifies
that's
it.
true.
They are doing work to it.
Yeah.
So.
Right.
That's true.
You know, for area variances, keep in mind, it can be self-created and that not be determinative.
Yeah.
Unlike with a use variance, if it's self-created, that's the end of the story. It's a veto. So. Okay, so I mean, it sounds as though, you know, all the factors are lining up in favor of a grant. Is there anything else that you'd like to ask the applicant or any other information? you'd
I
like to
don't
get?
think so at this time, unless
I'm fine.
anyone on the
I'm
board
fine.
does.
All right, then I think sequentially, I think you're ready to first entertain a motion to close the public
Yes.
hearing.
Make a motion to close the public hearing?
Second.
All those in favor?
Aye.
And
Next,
then I'd like to make a motion to grant the variance.
Second that.
All those in favor?
Aye.
Aye.
and then a motion to direct me to.
Yeah, I'd like to make a motion for council to write it all up.
I'll second that motion.
Most important part of that motion for expeditious purposes is to also authorize the chairman to sign it if, without having to come back to the board, if he finds it to be consistent with the proceedings here tonight.
I'll make a motion to have the,
Yes.
have to be signed by the chairperson.
Second.
All those in favor?
Aye.
Thank you so much.
Thank you.
Thank you very
Good night.
much.
Thanks for your patience.
Glad it took less time than the other one.
Yeah, yes.
So are we.
Yeah, exactly.
There was a motion to close the public hearing, grant the variance, direct me to prepare, and authorize Chip to sign.
Marcy. I think Marcy was the second on them all.
And here, who, George? Which one? It's the pressure.
Yeah. Do we have other business here?
No, I gave you an email from Nelson Luciano, who was unable to make the meeting tonight. He has asked to be put off till November. And that is all we have for this evening. July minutes have already been approved. August are downstairs.
Are you a student? Are you a student? Do you need something signed? No, because sometimes students come in, they need proof that they sat through a meeting. No.
Thank you.
Thank you. Okay, if that concludes it, I'd like to make a motion to close the meeting, the October meeting.
Second that?
All those in favor?
Aye.
Aye.
Aye.